The broadcast is lagging behind. Once again, welcome, dear colleagues. We are launching today's press conference. My name is Alexander Burmagin. I am the member of the National TV and Radio Broadcasting Council. Today's roundtable discussion is called the New Law on Media as a Step to Implementing the Recommendations of the European Commission in context of receiving a candidate country status for Ukraine. I believe everyone is aware that this is the first time discussion. The European Union has suggested a number of conditions as for the receiving a candidate country status, including the law on media, along some lines, reducing the interest of the private members, other services, and the empowerment of the institutional capacities of the regulator per se. I believe today's discussion will be meaningful and constructive. It will be the step that will allow us together to effectively and entirely manner to have the task implemented and come closer to our goals of the European goals and the long-awaited media reform. In general, we should be aware of the timeline. We will begin with the welcome remarks up to 5 minutes. The main block discussing the main body, the working members of the group will be allotted up to 5 minutes, and the format suggests that the first 2 blocks of discussion will go without Q&A. The third one will be Q&A, the discussion of the new version of the law on media. The last one will be conclusions. For those who are participating in the online Zoom platform, if you wish to participate in the discussion, you will be able to join in the Q&A session, but my request would be to have those questions fed in our chat for us to be aware of them. Once again, thank you very much for joining us today. All the panelists are here, and I suggest we should start. I would give the floor to the head of the parliamentary committees of the Humanitarian Information Policy, Mr. Poturaev. Thank you, ladies and gentlemen. For those who are participating in today's event, I would like to introduce all the members who have participated. And the participants, the list of them goes beyond the members of the parliamentary committee. We began to work on this in the 8th convocation of the Ukrainian parliament and even prior to that. So those people working on that is Ms. Kravchuk, the deputy head of the Parliamentary Select Committee on Information. Olha Gerasimyuk is the head of the National TV and Radio Broadcasting Council. I cannot help but note at this point and recognize our colleagues from the Office of the European Communication and Stan Norlov, head of the Council of Europe, European Office of Ukraine. Of course, they did not participate personally, but without the help of the Council of Europe office in Ukraine, this work would not have been successful. They were engaging European experts who are helping our experts to work on the text, for the text to be in line with the European regulations. And of course, without Mr. Norlov's help, without other people, I think both of them, including Mr. Norwell, are fully fledged participants of this project. We have other people like the deputy head of the minister who was working with it. Mr. Burmahin, today's moderator, he is currently member of the National TV and Radio Broadcasting Council of Ukraine, but he began to work with us as a well-known lawyer in media. We have other people, Anna Litvichenko, representing the national broadcasting, other people representing laboratory of media, Mr. Horovy working on the digital security, and the deputy sector, the public organization on the rule of law. Ms. Smirnova is the PhD in law. She works at the National Kyiv-Mohyla University. The list of participants goes beyond. Not all of them are participating this morning, but I am grateful and extend my sincere thanks to those who have been working with us in the course of the last 3 years, who've been working on this up-to-date modern Ukrainian legislation. Let me remind you that according to the recommendations, including Ms. Stefanishina, the first redaction has been submitted to the Parliament, and it was published in 2020. According to the table of consistency, it was up to 95%. It seems to be the highest level of consistency, and it only testifies to the high quality of work. So once again, thank you to all the authors of this, what amounts to almost a media code of Ukraine. Indeed, we were striving to come up with something like a media code, but we'll be talking about that need this morning. It must be consistent with the European legislations on advertising, for example. So there are a couple of questions that will have to be brought in line with the European requirements. And to the best of our abilities, we'll be working on the issue of media participation in the electoral processes. It will have to be worked on with our European colleagues. And of course, it will have to be streamlined in other bills and legislative initiatives. Not to abuse my time, I think we should go to the presentations. I would also like to know that we've been discussing a lot on these issues, meeting with the public organizations, beginning with the first reading in the Parliament after it was adopted and published at the parliamentary website. We were gathering recommendations of all stakeholders and people interested in that. In my view, as one of the co-authors, I think all the propositions have been taken aboard, or as they say in Europe, either taken aboard or have been taken account of. None of those was rejected, but this is exactly why we have come together to see if we read from the same page. Our goal is for this code to be in line and conform 100% with the European media laws, and it must be as inclusive as possible to make sure that the interests of the civil society, the media industry, and of course the state itself must be taken account of. We also believe that we've done a very good job and coped with the task to make sure that in the context of the full-scale intervention and occupation of Russia and the crime wars in Ukraine, not to what seems to be self-evident to make the regulation more tough, and more so when it comes down to military censorship. The law demonstrates right from the beginning how consistent Ukraine is with the things of defending such values as freedom of speech, freedom of media, and freedom of thought. That is why, even given the tragic situation that Ukraine finds itself in, all of us, the representatives of the media and the politicians and regulators who are still working either in public sector or in media per se, one thing or the other, we all have sprung from media sector. We speak the common language. We've done, in my view, and of course it may be argued, but I think we've done everything we could to make sure that this law balances, in the first place, the basic principal rights and freedoms and the necessity to protect the societal interests and interests of the state, especially given this cruel war against Ukraine. Thank you. I would like to give the floor to Yevgenia Kravchuk, who is the co-author of this bill and law. Thank you, colleagues. It's raining outside, and it's good that you've made it here. I think this law is adopted. It is one of the laws that has been discussed for the longest period of time. It's about the third year, but let me remind you that this is now the 10th year of our commitments before the Council of Europe, and we are thankful to stand for joining us together. But currently, it's not only a commitment to the Council of Europe. It also depending on the general process of European future of Ukraine. The negotiations will not continue until the Ukrainian parliament does not adopt or implement the law on media and the directive. Let me remind you that 7 criteria that we know about the law on media is one of those criteria. Let me remind you, it's not the fact of adopting the regulations on audio and media, but also the decrease of the influence of the private interests on media in general. Of course, the vested interests, of course, are here, and big capital must not influence Ukrainian media sphere. We also should be mindful of the role of the regulator. In fact, we are talking about the consensus between the state that is called to protect the interests of the general audience. And of course, we should be mindful that the regulator is aware of that. Let me tell you that the regulator, and it is spelled out in the Constitution, is an independent body. And there were a couple of changes in the law, but it will be reflected in the law on media. I am convinced that in autumn, we will see through 2 readings, but as far as deadlines are concerned, the 1st of December is the timeline for this law to be signed by the president, and then it will be part and parcel of the 7 criteria that I have mentioned, and it is up to the members of parliament to show that we see the progress in this area. Let me also tell you that in the version that we adopted in our parliamentary committee back in 2020, it has undergone the expertise assessment with the experts from the Council of Europe. Back in 2020, this version of law was green-lighted by the European Union structures. The Swedish, Canadian offices, missions here to Ukraine said, okayed it. And perhaps in some time, we will see how these things will go on, either through the amendments or through the second reading that will amend the first one. But this is an attempt to implement 100% the European directives. We are trying to meet the requirements of inclusiveness, in terms of accessibility of impaired people, disabled people, and things on advertising. Perhaps my colleagues will go in detail on each of those chapters. But of course, why this law is important, it's part of the 9th chapter, especially when it comes down to the security of the information sphere. It is part of the Constitution. It's a duty of every Ukrainian citizen. Thank you very much. We will be answering your questions later on, but it is important now for you to hear the presentation of the task force on the changes that we suggest. The floor is given to Ms. Gerasimyuk, who is the head of the National Council. Thank you. Welcome, dear colleagues, everyone who have and who has joined us online. I would like to join in those heartfelt words of thanks for those who've been working, for those who agree, for those who criticize main message, because what we are seeing today is, in my view, with no exaggeration, is an historic act. We are all united by a desire to reform the Ukrainian media sphere the best we can. That's why all the messages that will or have been voiced are important to us. I am personally thankful, and I was looking at the work, heroic work of this task force, working 24/7 for all the fact that the phrase is trite and outworn, but this is true. So once again, a historic event. Why is it so? We've been working on this law for almost a decade. The law on public media was adopted right after the revolution of dignity. The aggressor is trying to kill Ukrainian identity and kill Ukrainian security. Now that we are talking about this, I'm thankful to the Council of Europe representatives. They've been helping us with their expertise, and I think we will work with them in the future. So I believe that this will be a groundwork for the living up to all the requirements and a roadmap for the future changes. The European Commission indeed indicated that Ukraine, in these challenging testing times, when their aggressor is trying to destroy Ukraine as it is, has managed to cope with this idea of balancing that is so difficult to do in times of war, when some things must be restricted, but at the same time, the freedom of speech must be guaranteed. So the Council of Europe mentions that the 3 challenges that we are seeing, and I am echoing here what my colleagues have said, we are coping with them in today's discussion. There are main 3 challenges, not all of them, but major. The overcoming the excessive private influence and introduction of the media and video and audio visual materials, and the strengthening of the role of the national regulator. I think this is the most challenging topic for the discussion, and I support this meaningful discussion. And I also would like to say a few words about the key positions. When we're talking about overcoming the excessive private interest, it's not that the EU is interested in this. The Ukrainian society wants this. We want to see the transparency of the media activities, the transparency of the ownership system. The Ukrainian society has wanted for a long time to get away with the abuse of resources during the electoral campaign, because it can influence the results. So all in all, and I echo the point that there is a special mechanism on anti-oligarch law. It's now been effected, and we are discussing something that is very novel for Ukraine when one of the owners of the campaigns has shut down his businesses. There are many interpretations of this, but I think that it's not the anti-oligarch law kills the Ukrainian media. It is not. The second point is visual and audio project. Today's project that has been registered now for 2 years on the site of the parliament foresees such demands. We've been in constant dialogue with our European colleagues, and the most exciting thing, the strengthening of the role of the national regulator. We hear different voices from different quarters. I wish these voices were always using strict facts so that we might have this discussion in a constructive way rather than indulge in populist rhetoric. Let me also turn your attention to Article 130 on audio-visual services, which quotes the independence of the national regulator, either from the state or from the private interests. It's a well-known model in Europe. This is where we are edging towards. This is a requirement. This is a need. It's not a need of the country, of a state, to implement censure or more control or something else. The European Union countries that have seen the strong regulators, we can take on board their expertise. Ofcom, for example, in France, those interested, you might look at that. They've been empowered to regulate financing, the freedom of speech, artistic work, securing the customers' rights. You can also travel to Spain, where there is an absolutely independent body called regulator, enjoys absolute freedom either from government or participants of the markets. It is not dependent on any private or invested in interests. We can look at any country where Ukrainian media are present. You know, we are members of the European platform of regulators. This is a topic that is actively discussed over there. Of course, we have this fully European expertise as for the whole media market. My message is this: Ukrainian authority must show the authentic independence culture. Independent regulator means independent media. I believe I'm drawing to a close. The empowerment of the role of the Ukrainian regulator. By doing this, we also improve the quality of information, share of information on the terror of the state aggressor that we share with our European colleagues. We have now seen and are at disposal of the mechanisms that we didn't have before. We were regulated by the tools after the independence and didn't empower us to react to different developments. We saw the situation when Ukraine was accused of terrorism. As for when the narrative was propagated about the civil war in Ukraine, those accusations were targeted at Ukraine as the country that has fulfilled its own misdeeds. We didn't talk about collaborators. We did not mention the facts testifying to the information war of the aggressor. Now the situation is different. And by the way, the aggressor country is not only Ukraine. We might also talk about Belarus. if there is a way to mention this in this law. I could go on what in reality the regulator's independence is, but I think Mr. Burmahin calls on me to draw the line here. I think we will have a discussion. The head of the Governmental Office on European Coordination. Thank you, dear colleagues. We've met a couple of times under the auspices of the committee headed by Stefan. We've been working on this bill for a long time. A lot of work has been done on analyzing the law itself. And I would like to share with you that practically all the discrepancies that we saw in these directives have been improved, and it's on the website of our select parliamentary committee. Let me tell you what is going on to happen. We have given over the translation of the Ukrainian text so that through the verbal note, we see the assessment by the European Commission. The European Commission is likely to assess how this document implements the recommendation that they have offered in their decision on the Ukraine's candidacy. And after that, we will have a discussion whether we have the recommendations to be taken on board during the second reading in the Parliament, especially in terms of the decrease of private interests influence and the independence of the regulator. Now, in case they're happy with these reductions, and of course, we count on the fact that this bill will be signed into law by President before the 1st of December. Because at that time, the European Commission will be assessing the implementation of the second recommendation that we have received, part of which is the law on media. As for our main remarks, we were advised in our observations to be more specific on the powers of the regulator to remove the provision for not paying the new enumeration in terms of the copyright and increase the possibilities of the disabled persons. Altogether, 5 points. There are a couple of minor remarks, and all of them have been taken care of in this version. Thank you, Natalia. This is very important. And of course, we'll be talking about that. Taras Shevchenko is given the floor. Thank you. He's the Deputy Chair of the Ministry of Culture and Information Policy of Ukraine. I believe every Ukrainian will agree that European integration today is one of the priorities of the Ukrainian society, for the Ukrainian society, for our security including. The sociology tells us that up to 90% of Ukrainians want this country to be part of the European Union. When the approval process of the media law is an integral part of this roadmap, and I think this road will be covered very swiftly, but at the same time, openly, transparently, for everyone to be enjoying the right to voice their concerns. And today's discussion is one of those options. The published text is also an evidence of that, to the fact that the authorities are open to discussion, to proposals. We are transparent. We want to hear from the international organizations, businesses, and public organizations, but we want to move very fast. It is incumbent upon us and only upon us that we live up to the target. What I most like in this is the process that reminds me of how we received a visa-free regime. This is where we saw the clear-cut goal. Perhaps not everyone believed that someday we will see the day that we will enjoy this visa-free regime, either on the Ukrainian side or on the side of the Europeans. But we covered that path where we saw that the green light will be there unless we live up to the commitments. And I am sure that this will be the situation this time around. Of course, it includes the issue of security information of security. The governmental bodies must know how to respond to the challenges that we face. And unfortunately, we didn't have such mechanisms until the war broke out. We remember the stories about Channel 112, the news that, if you will, forgive the word News One channel, which not a news channel at all, and other media outlets that we all know about. To conclude, the Ukrainian media legislation is going by leaps. We saw some basic laws in 1990s, then at the beginning of the noughties we made next steps, and for some time the Ukrainian media law it got bogged down. It did not develop, and we now know that the new legislation must be implemented. Europe is very different. Of course, there are documents that we strive to live up to, but we also are aware that in EU, yes, there are directives, but every country has their own specificities. So Ukraine will be able to implement these recommendations with the Ukrainian ideology. The floor is given to Sten Norlov, the head of the Council of Europe office in Ukraine.
Дякую. Доброго дня, шановні учасники.
Thank you.
Експерти, колеги.
Welcome to all colleagues and experts.
Ні.
Ні, там просто це для it's for translator.
Yeah.
This is for translator.
Yeah, this is for translation. Okay. Sorry.
Можливо, тут треба. Отак можна.
Просто він не бачив, що я в зумі.
Тут динаміки йдуть.
Я сьогодні зараз.
Я говорив.
Окей.
Може, всім зрозуміла українська? Може, ми обійдемося. Там тим більше ви розумієте англійську. Окей.
Виключити.
Okay, here we go again. A little bit of echo. But of course, we stand by Ukraine in the extraordinary circumstances during the full-scale war against Ukraine and your effective work on the draft law on media. The Council of Europe have been working with you for 10 years, and I think you mentioned it. It's very good that the dynamic of the candidate status now, so to say, gets the work over the goal line. But I would like to appreciate the work that has been done over the last 10 years within this field, including on the public broadcaster, setting up the independent broadcasting advisory board, and so on and so forth, which is part of this. The adjusted priorities of the Council of Europe Action Plan for Ukraine for 2018-22 have been adopted, and the project, which I mentioned, Support to Safety of Journalists, Media and Access to Information, has been launched. This joint program is joined with the EU, so the Council of Europe and the EU work very closely together, and within this project we have provided extensive expert support for developing the draft law on media to partners and to the working group, facilitated public discussions of the draft law, and trying to assist in reaching consensus among key stakeholders present here today and also on Zoom around the problematic provisions, provided expert access, expertise to comprehensive training activities. We have been organized to different stakeholders on the Council of Europe standards and provisions of the EU AVMS directive, as was mentioned also by Ms. Kravchuk. We have also tried to assist in raising awareness campaigns around Ukraine in order to engage the public. You have to remember that the Council of Europe, we work with both human rights, rule of law, but also democracy, so engaging with civil society is very important to us as well, and to Ukraine, obviously. Today's discussion of the draft law on media is, of course, timely and important for ensuring the inclusive and transparent legislative process with proper information and engaging of civil society, media, and associations which will be affected by the law. The Council of Europe is ready to provide official expertise of the revised version of the law between the two readings if it's necessary. We will try to respond as fast as we can. We have lined up experts for that purpose should the need be. We consider the adoption of the media law a priority for solving the challenges in the audiovisual sector, which are still there. The new media law should create a single, consistent, comprehensive legal framework, which should lead to effectively regulated media environment. And here I might just add that it's correct. The 3 points that you mentioned, of course, are important, but it's also important to have a good law that the courts can also work with afterwards, of course. The new law should modernize the present legislation and include regulation for new types of media, as mentioned, audiovisual media, on demand and video sharing platforms, which have become widely used. It should also strengthen, of course, the independence and effectiveness of work of the media regulator, the National TV and Radio Broadcasting Council of Ukraine, and facilitate development of community media in Ukraine. Here I would also add, as Mr. Shevchenko said, that of course there are many models on this regulator around Europe, and here I think the diversity within the EU, so to say, has to be explored by you. The important thing is that in the end, of course, is the independence and how that is being handled, so to say, and there are different models. The EU Audiovisual Media Services Directive has a lot of benefits for Ukrainian media and citizens. It provides regulation of video sharing platforms, better protection of minors from harmful content, strengthening independence of media regulator, and encouraging and self-regulation and promoting media literacy. I'm looking forward to today's discussion and to listen to the different points of view, and is of course ready to participate. Lastly, I would just say one last thing on security, as it was mentioned by Mr. Shevchenko. I remember he and I actually participated about a year ago, almost to the date, in Odessa. I hope we'll come back there soon, in a discussion with young people on different ways of regulating in Ukraine. And some of them were sort of promoting and saying, isn't it easier with reform if you centralize, you put in a dictator that would make it all, and then you get away with all of the vested interests. And I think, wouldn't you like the job? I was asked, and I said, "What if I had that power? I would give it away immediately." I think the important thing here is exactly that this law, over 10 years, and now coming into the final sprints in order to be taken, has been widely consulted, and that this process of trust between the different parties should persist. Of course, taking into account that Ukraine is in war, it's been invaded by Russia, and that of course has some challenges that persist in this. And of course, there will be certain things that will be regulated by military law, but that should not, so to say, take away the quality of the basis of the law, which will persist after the military law has been taken away, and Ukraine is a free and independent country within its natural border, within its recognized borders again. So thank you very much for the word.
Дякую, пане Стене. Дійсно, теж хочу подякувати Офісу Ради Європи в Україні, тому що Офіс Ради Європи в Україні дійсно був завжди поруч під час важливих змін.
Thank you, Stan. Your office has always been standing with us and shouldering our burdens. We appreciate that. We are now into the panelists' discussion, people who've been working on this law media and the amendments that were published on the parliamentary side back in 2020. Let me tell you from the beginning that the participants have familiarized themselves with the text, so we'll be discussing major points, and perhaps during the third part of discussion we'll talk about that. The National Council point. We have 3 panelists here, but I would like them to briefly outline the things of responsibility, licenses, and licensees. All the presentations prepared by the panelists will be available on the Council's site, and you will be able to get acquainted with them. As for the Chapter 6, the powers, this is a systemic point. What is new in this new version? A lot of norms were relegated to the sub-laws categories, including procedural things. The experts of the Council of Europe draw our attention that this law is too complicated for understanding. There is too much detail in that. As for the guarantees of the media, this will stay in the legislation. The regulating and oversight functions will be divided very clearly. What is important here is that in some points, the things were confused, but they are different functions of the regulator and oversight functions. So when we discriminated between them, the regulator has been empowered to act more independently. For example, when the structure of ownership, when there are signs that the ownership goes to Russia, then there will be special response. As for the implementation, since we have seen since 24th of February, in the information sphere, we know this law has been outdated. No one touched it for 2 years. It's been sitting there on the website for 2 years now. We have adapted it to the today's realities, and terminology has been updated. We have also unified and are working on the adaptations of the law on all European referendum. It should be up to today's challenges that we are seeing. Next slide. Improved has been the points of responsibility and structure of ownership. Of course, I will not go into detail. We have a special point there, we have added a new responsibility on the fixed sum of finances from the state budget. At this point, the number is 0.22% of the national budget. Political independence of the regulator. We have taken away the norm that was strictly criticized by European colleagues, and it was the taken advantage of to suspend the activities of the Council on Broadcasting. This is the provision that has been under constant fire of criticism, so we got rid of that. The independence of the National Council on Television and Broadcasting and its implementation. It's not the matter of getting rid of that particular point. The bill very clearly still stipulates that these bills must be publicly discussed. There must be explanation notes at the level of the government. So we have written down the whole structure of communications of suggested bills for the stakeholders to be aware of them. As for the regulator, the mechanisms were thought to be abused to influence the regulator. We have also renewed the restrictions on the membership, and the corruption law has been changed, and other legislations include the requirements for such independent regulators. And in this part, we have also brought it in line and conformity to the European Union requests in terms of the membership of the National Council. We've also written down the point that Parliament must have its representation. We know how the competition for membership was criticized and other points. We've got rid of those points. Of course, the competition for membership will be open. It will include the gender balance, and we will account for the equal number of women and men, and the ability of president to set up a competition council. There were a couple of requirements here, but we were also informed that we cannot write that down in the procedural activities of the parliament, because this will interfere with the powers of the president. We have also foreseen this point in the new version. We have changed national representations as it is currently suggested in the law. This is a more clear-cut structure. It is well understood. It gets rid of the red tape, and the number of officers will be in conformity with today's needs and realities. We have also stressed the guarantees for the national regulator. As for the powers, Article 90, we've rewritten and restructured the article, but there are two main things. One novelty is the structure has been more lucid, and the other innovation is that we have added the powers by the National Council to transfer some points that were laws. We've put them under the category of bylaws for the council to be able to develop bylaws. As for the message of Mr. Stefanishin, this article says, and I quote, this the closeness, the secret nature of the clause has been restricted. You see, this is a tradition of the Ukrainian legislation, that there are a lot of powers of regulators provided for in different codes, anti-oligarch code, for example, and other bills and regulations. So the list is there, but it has been dramatically reduced. Dear colleagues, I will be brief. This particular article has not seen serious changes, but there are serious changes anyway. Alexander has mentioned that we divided between regulatory and oversight authority as for the structure of ownership. What we saw on the task force proceedings, we saw the difference between this. There is a subject that requests some documents, and it must meet the requirements of, for example, transparency. If such a body breaches some requirements of transparency or the structure of the element, sometimes it goes as a control of the over-regulator, leading to different fines. The concept has been changed. It's very simple. When we see non-conformity of the structure of the ownership structure, or it's intransparency, we begin with the communication. First step is when we talk about the competition or licensing, as a verdict will be not allowing this the subject that is not conforming will not participate in the competition. Secondly, if this request does not live up to the Ukrainian legislation, so actually the subject matter that does not comply with the legal requirements will not enjoy the conditions to survive in this market. It's very clear. It will be understood by all the members of the market. If the body does not conform with the legal requirements, for example, hate speech, we are empowered to look into the ownership structure and other steps. We have also obliged the subjects to comply with the financial documents until the 10th of April, excuse me. There will be, the 10th of June, as it happens. This requires a great deal of depth of documentation. Every subject matter will have different requirements. This is all for the structure of ownership. Additional services and possibilities in a bullet format, if you please. The thing is that we've got a register of the actors of the economic activities, and it talks about production companies and licensees, and this also concludes the general situation. The register is the main database. There will be also a list of foreign media. And it will provide for the opportunity to bring in line all the information on statutes and activities and и так далее. So there is an exhaustive list of the things to be lived up to when we talk about the data that are open and public and those that are legitimately not available in public sphere. We've been asking for decades about the following point. New interactive tools for the cooperation of the National Council with the members of the market. The toolkit provides for the opportunity for the request to be analyzed by the council. It also provides you are supposed to provide information on the structure of ownership. The main thing is that this electronic cabinet will be used for different activities. That we will be using, and those interested in this will be able to look at this information. I would like to give the floor to the head of the laboratory of the digital security. Vita has been a lead expert on regulation of online things, and this is the part of the legislation that has seen major changes. Vita, the floor is yours. I've got a presentation here. I will highlight major changes. The law indeed, for the first time, regulate the online media. That's why this is very difficult to come up with a model that will find a balance between providing for the information security and at the same time not restricting freedom of speech. What we did in the first place, we very clearly described who are considered to be media outlet. So what is online? Outlet is online press in a very traditional meaning of the word. Apart from that, on the next slide, there are requirements and demand for the mass media to be regulated by the National Council. If these media come to us and register as such, and they claim to be online outlet. And secondly, these are situations when media online are doing something online, but they don't want to get registered as an online outlet. That's where the regulator will see that this body lives up to a number of requirements. This is a very special category. We have added a point for them that the criteria for the media outlet to be considered as an online one, there must be very specific criteria. Another thing in the new version, it used to be there, but we wanted to have this a more clear sounding. Online bloggers, that is people working on YouTube where they professionally do execute their professional activities, they will have to get registered. So in one way, they will take on some responsibility in terms of transparency, and they also will enjoy the rights guaranteed by the law itself. The National Council will not regulate all the bloggers of Ukraine unless they have wished to get registered. A next point is this, beginning with the 24th of February, we have seen new restrictions on the information that can be divulged. That's why the mass media must not disperse information of the symbols of the aggressor state and so on. The most drastic change has been in this sphere. This is where we tried to implement this balance between restriction and the freedom of media, and we think we have come up with a quite complex and developed system, because we've got registered media, non-registered media, anonymous media outlets that we don't know who are behind their policy of information. We have also developed a system of response by the National Council to the perpetrators. If the law is breached, there will be a number of recommendations, and we also have prescriptions and then fines for different law breaking. The prescription will be first step, and there will be fines that will be clearly defined, which is important. Another point of how to respond is the registration. Of course, it covers only registered media, and it is not implying the suspension of the media activity. If the media make more than 5 serious breaches of law, it has to do with the mala fide activities, and they must prove that they are working in good faith. But at the same time, they will not be stopped from working, but they will be working under the regime of the non-registered media. Another 2 ways to respond is temporarily suspension or rather banned. Once we have seen grave breaches of law, which include the call for the violent overthrow of state order, support of the aggression, the list is there, and the ban on distribution. This can only be done through the verdict in the court once we have seen 3 breaches of law. The court liability is also available. It depends on the number of breaches. Once the breaches are serious, there will be other ways to respond. There are also tools. If the legal prescriptions have not been worked on, it will lead to other steps. National regulator will be able to ban the activity of such an outlet in terms of enforcing the ban. So once again, we are talking about the mala fide and serious breaches. The new version includes also 2 points when there will be foreseen the point that you are not held responsible. There are certain points. For example, you are released from or exempt from responsibility if it concerns only your archives and not your update activities. Now that Russia is attacking the resources of non-governmental and governmental organizations, if unlawful information is distributed by the outlet that has been proven to be hacked by the aggressor state, then they will not be liable for such breach. Thank you. Maxim Zverovy is the lawyer at the Laboratory of Digital Security. Let me also remind you about the general nature of directive. let us remember what it defines, what it does not define, to leave alone all those myths. You see, living up to the directive on the media services, we worked with the history of definitions, with the history of jurisdiction on audiovisual media. We also promoted the idea of self-regulation and the shared platforms and the idea of independence of the regulator. There are 2 points that are very complex, and it has been mentioned today. The history with the advertising. We have a special advertising legislation. And second point is the freedom to rebroadcast European media. We cannot live up and conform with that requirement today because we are not part of the European body. When we talk about retranslation coming from the EU member, the mechanisms of cooperating provides for the ability to turn to the European Commission or to ERGA. We are not the member of the European Union, so we cannot take advantage of these tools. So basically, we had to invent our own recipes, how to restrict the Russian mass media that are working and masking themselves as media in Latvia or in Estonia. Some people on the internet are saying that this is a provision that Ukraine will not be able to implement in full scale. But what we should be mindful of that there are some provisions that we can step back from our commitment if there is a possibility to retreat, and there is a whole list of such commitments when it comes down to internal disruptions or situations that or foreign aggressions. This is exactly what we are seeing now. In the current situation, we cannot guarantee the full-scale rebroadcasting of foreign media outlet in the territory of Ukraine. One of that is that we are not access to all of them, and secondly, the circumstances do not allow. If we are talking about the retreat from commitment, the so-called digression under the armed aggression into the territory of Ukraine, this point has a number of novelties here. The previous procedure was we have prolonged this norm for five years. We have also specified the content that will be banned. We have detailed procedure of blocking of OTT services of the aggressor state. This is a problem that has to do with the dissemination of the content by the Russian media that have been banned in traditional media and the media content. We have also foreseen the powers of the National Council to turn to international and foreign platforms and asking them to ban or restrict the use of that content in their territories. We have also come up with the blacklist of artists, actors of Russia. We've been guided by the Security Service of Ukraine. In the first place, they were recommending to us the list of those persons, and we've made an effort to regulate this point so that we don't see on the Ukrainian television or radio or in Ukrainian online content in general, that to make sure that we don't see these people from the blacklist altogether. We have Igor Raskladai. He will be talking through Zoom platform. He the leading expert in his organization on rule of law and other issue. Can I share my presentation with you? Let me take a step back to remind you about the philosophy of the chapter on responsibility. The current legislation talks about three spheres of regulation, including the warning, fine, and ban. In 1994 to 2016, fines were not provided for. The history with the fines that began in 2012, the National Council suggested that back in 2012. This is one of the arguments why the regulator must be free from such procedures, negative procedures. This legislation provides for Article 99. It is called the response of the regulator in case the legislation is breached. The task force has taken a fresh look, and we have decided to make it simpler and to write it down in the following way: the respond actions for possible breach of the legislation. In the next slide, what you see is the different recommendations, but what we have seen in this provision, it has been also already mentioned, we wrote down the law's provision. The idea of prescription is not there in the current situation. It's only to serve that there are some problems with the conformity either in your license or in your activities, and you are bound to live up to the state. If the prescription doesn't work, then the fining system comes into place, and the ultimate point is the abolition of the license. We should be aware that the law discriminates in Part 9, where the National Council passes a decision. We are talking about the specific time that we are now finding ourselves in, or the cancellation of registration, or the banning of license of the printed edition and activity. This bill 26/D, there is a ranging of the violations. Every violation has been given a new meaning. You will see that the chapter has grown dramatically because we have suggested different types of media. As an example, you will see the subjects of the so-called linear outlets, non-linear broadcasters, so forth. As for the printed media, online media, and every category will be defined in terms of the possible breaches of legislation and according responses. A number of violations that will be held accountable include the extended list of discriminatory violations. We have expanded the group of such violations. The second point is that the definition of the humiliation of the state language. A new point that have seen the light of the day is a positive description of the authorities of the aggressor state. The grave violations include the violations that have to do with the propaganda of Russian Federation as a fascist state, the positive information of the Russian aggression of Ukraine, and the unchecked factual distribution concerning the war. As for the exemption from responsibility, Vita mentioned the online, and we have also added the point of reproducing materials from the foreign media. What is implied here is this: when we reproduce something that is written in English, you should provide a reference to the source, and sometimes it has to do with the translation. This is very important, that the translation reflect the essence of the original. In general, this responsibility chapter has changed dramatically. It must be investigated very seriously. It must frighten you by its sheer size. But we wanted to make sure that every type of the media that you are interested in, you should delve into that particular category rather than fishing for the information as it happens in other general legislation. This is where I think I should stop. Thank you. Katerina Mesnikova is the executive director of the national media. She leads two major, what has been light chapters, that are not criticized as others have been. And we have a question on this point from Mr. Pogorelov. Why is it that I am receiving the most of criticisms? The co-regulation is a novelty, and all the experts that are writing to me say it will not work anyway, because the state and the NGOs will not be able to see eye to eye. But I believe that this is possible. Co-regulation still remains a system that combines the regulation of state regulation and self-regulation of the industry. I think this is where we see the request for the quality of content. And we are in the situation when it doesn't make sense to give everything over to the state. The government will censor the information in one way or the other. These are sensitive issues. And of course, the state cannot provide for this situation where there is no oversight. As for the provision of the participation of the media and their participation in the legislation, and at the same time we want to preclude the censorship, and this balance is a fine balancing act, of course. There are two novelties here. A lot of criticisms has been seen by the point that self-regulation will be squeezed away and other way of self-organization of the media community. We were trying to say that this does not restrict your ability to self-regulating and self-organizing as the business in general. And secondly, what we are saying here is that there will be bodies responsible for the self-regulation. The co-regulation is very specific, which is seen on the next slide. the subject of the cooperation must be very extensively and exhaustively written down. The law provides that there are specific focal points for the self-regulatory work. As for the subject matter, we have changed some formulations. As for the list of criteria for such media, the definition of the criteria for the information has been increased from 12 to 30 points. The sum will be subparagraphs on self-regulation, and on the next slide, if I understand it right, new 2 points have been added as a response to the demand on the directives. The information on advertising may be considered as harmful. We've mentioned that the partial implementation of the recommendation must include the fact that co-regulation must specify and put in clear black and white this point. The co-regulation will also involve the plans to secure inclusiveness. Together with National Council, we are striving to promote the idea of how media can expand the inclusivity and possibility and access to the disabled persons. Next slide is the system of bodies. We've drastically changed the approach. The members of the market had a lot of criticism. They were asking how should we come to general terms between audiovisual media services, and we have foreseen some bodies of co-regulation between different types of media, audiovisual media, and a separate point that I've been asked about, and I will comment on that, the platform of shared media. This will be exclusively Ukrainian. We don't divide the Facebook or other international actors to participate. This is only for the Ukrainian subjects to regulate and set up a body of co-regulation. It can be done under the initiative of the subjects in the media sphere that have been in the market for more than 3 years. So we are talking about the players that are known in the market, and the order of setting up this body of self-regulation has been changed. National Council must turn to the initiators. It takes 10 days to announce the task force. 30 days is given for receiving of the requests and biddings. National Council is restricted in its ability to turn the request down. For example, if the subject is on the market for less than 3 months, or the documents have been provided in a unspecified way. Then there will be voting for the members of the task force that will be made up of 12 persons. Why is that? We want to raise up the efficiency of the task force, and the specific nature here is for the audio and video means. 4 out of 12 members must represent this kind of media, 2 representing all Ukrainian responsibility area, 5 people from regional categories, and 2 the so-called platforms. Why is it done? We've analyzed the complexity of the market. We want every stakeholder's interest to be looked to. Starting from now, the count is deemed to be approved, and it is a duty to set up such a group, 1/3 of which will be constituted by the representatives of the National Council. Then it will be approved by the board, then by the National Committee. There will be check and balances procedures, and after the adoption by the board and by the National Council, the code will be given to the signature. After it has been signed by 50% of the members, it will come into effect, and this will preclude a situation when there will be a legislation not signed by some people that didn't sign it. So this is all about the co-regulation point, and I think it makes sense to work the way we do, go point by point and article by article. Last but not least, the distinction between regulator and oversight functions. Ms. Smirnova is a PhD of law. She works at the National Academy of Kiev, Mohyla. Can you be as simple as possible, please? I can. We should focus on 3 principal novelties here, registration included. Can you hear me?
Перше питання, яке стосувало змін, пов'язано якраз з розподілом регуляторних.
Now, the first novelty is the distinction between the powers of the National Committee. When we talk about the annulling of registration, we should be very clear which function is performed by the National Council. You see, everyone thought that cancellation of license was seen as censuring. This is not so. There are some demands and conditions for the subject that we call basic demands. The openness of structure, of ownership, transparency of it. These points are very clearly defined. So non-conformity of the subject to such basic criteria imply the canceling of the registration, mind you, by the council. And there is no point of arguing if your structure of ownership is not transparent, or if in your ownership there are people with the Russian passports. So there is no point in going to court. It's very clear. You can provide appeal to the regulation by the National Council. In other words, the cancellation and annulling the registration is a regulatory function of the National Council, and as an oversight power is their ability to look into the breaches of the law when they are entitled to turn to the House of Court. First point. Second point, the chapter number 5 about cancellation of licenses. We don't want to see any misinterpretation in this sphere. And the third point is our main expertise within the environment of the full-scale war. This has made it very visible that the normal procedures of communication with the government authorities don't always work under the martial law and in times of war. So we've seen new novelties. National Council will be able to guarantee that the market is developing, that the licenses are prolonged, that registrations are prolonged, not for us to wait until the end and lifting of the martial law. This is when we talk about the licensing and registration. At the first sight, we thought there was a lot of work to do, but basically it has come down to 3 points. At this point, I think we should move to the most exciting point, which is Q&A. I would like to give the floor to those that I am sure would love to be recognized. And then we'll talk about the proposals. You have up to 3 minutes. First is Oksana Romanyuk, the Executive Director, Institute of Mass Information. Thank you. It's been a very interesting discussion. We've read the second reduction that we've seen on this site of the Select Committee. We've seen there are lots of positive changes, including more specific depiction of what is considered to be online media. You have got rid of excessive excessive control. In general, it is safe to say that we like this variant that we've seen on the site of the Parliament. For a couple of key points, I would single out 3 of those. First is the independence of the National Council. I think the fact that from the legislation you've get rid out of the commission that recommends to the president the appointment of the National Council. We believe this is a way to non-transparency. I think the commission should be returned. This is not a restriction. The Ukrainian constitution provides for this point. So as a step towards transparency, it must be done. The financial and political independence is an asset, of course, but after Ukraine has secured victory and the martial law is lifted, we will raise up the issue of amending constitution to ensure the independence of the National Council. As for the online media, a couple of nuances here. At this point, I would not tread on the territory of regulation of YouTube. In the European Union, you see a lot of discussion going on now. This is a complex issue. I would postpone that discussion until future, so that the demand in the directive must be reflected. When I was listening to you, a media has a YouTube channel. It must be registered as an additional media. There is a collision here, and unfortunately, I don't see the representatives of the online media market. Telegroups are represented here, but not online media are not represented here in any form. I would like you to get them involved, including the discussion of these regulations. And I also have an impression that for the online media, the regulation has been improved. It has been more balanced. Online media, what we see here is that there is more regulation for online as compared to the audio-visual media. I don't see the blocking procedure for the audio visual. So we must make up our minds whether we guarantee the equality here for the audio visual and the online. As for the one bigger and painful question, unfortunately, in this bill, what we have seen are a number of provisions that weaken the tools for securing the national information space. I'm reading to you Article 50. Major breaches of audiovisual matters will be considered the 10% excess of the European volume. In such a way, we expand the quota by whopping 10%. The quota that in such a way have been expanded. I believe that in the current circumstances, to expand such a quota is unacceptable, and with no beating around the bush, we will not accept such a point. And the list of persons that threatening national security. We've seen the approval of provisions that have been approved. In the law 2310 in June was signed by the president. It has come into effect. Why should you revise these provisions? Doesn't make to me. We have a document from the Verkhovna Rada dated 14th of June. The interpreter thinks there is a list of persons. Why should you do away with the previous list and come up with a new one? Why would you not copy that list and incorporate that into the legislation? Why not take advantage of the legislation provisions over the last 2 years? We have seen 5 amendments over the last 2 years. Some of them have been included, some of them have been excluded. Well, basically, these are key points that I would like to highlight. Another issue is we would appreciate if there was a bigger chance to discuss, to argue on some specific points. Thank you. As for the online sphere, we had a number of meetings with the European partners, and such meetings will take place. As for the different lists, black lists, blue lists, violet lists, I think this must be regulated in all the area of universal regulation that have to do with the restriction of the impact of the Russian culture. In one way, this point must be addressed by Vita or Maxim. As for the online, I will say a few words on the platform. YouTube, as a YouTube company, as a shared platform, video shared platform, as it is singled out in the directive. So there are a lot of preconditions that we must implement into Ukrainian legislation. But the platforms of shared access to video are concerning not the YouTube, but the platforms that are likely to be set up in Ukraine. If we have an analog of something like the YouTube that will be set up in Ukraine, it must be regulated within this recommendation. Indeed, we cannot afford not to regulate. As for the YouTube channels, they are not regulated as YouTube media. That is to say, if a person loads up some information and it's done on a regular basis, it has the features of online media. If they want to get registered, to take part in the self-regulation, co-regulation mechanisms, but to regulate all the channels. We will not do this over the whole YouTube. Will you get them registered? No, this is what I said. The media is considered to be online press, but if the blogger wishes so, they will be equal with the online media. However, you should remember, any government body has to do with the national legislation. They can turn to YouTube, to Facebook, to delete such an information in the territory of a specific country. To follow up on this point, as for the registration of specific users of the YouTube, there is no information available as of now. We have received commentaries from the consumers, from the users who wanted to get registered as online media. So we are now coming up with the way to respond. But we want to make sure that we don't have the request from the non-registered media, because they are non-registered online media. This work is still in progress, and we will publish it later on. As for the lists, it is partly my own point of view, partly the point of view of the task force. My personal take is that combination of the black and white lists is a non-regulated nonsense. I don't see the sense in this. I don't know how the lawmaker wants to have this in a more or less logical way combined. We will work on the concept that has been said, as I'm saying, to combine the black list with the white list, and we've decided to do this. What is more or less agreed in the primary draft, which is the blacklists. Blacklist is actually criteria-free list of the Ukrainian Security Service, and we received that since 2020. It has been developed to be more specific in defining our criteria and to give it over, suggested to the National Council, then to the National Council of Defense and Security, which seems to be performing actions that are not non-core activities for them. But as far as the blacklists go, I will insist on this concept. This point is at least well regulated as compared to the random exclusion or inclusion. As for the communication, the members of the task force are well known. Is it possible to communicate with them directly? And we will try to set up a special meeting, a topical one, for example, on online format. We should also be mindful that we will see the second reading. Of course, all the proposals are welcome, but also I think I should remind you on this. Any proposal that shall not go through the European filter will not be passed. In other words, there is nothing in this law that will engage the membership negotiation that we are likely to hold with the European Union. I will not go into detail. What Maxim has suggested, and Alexander mentioned the blacklist, the white lists. The point is this: all the controversial points from the point of the European legislation shall not be part of this law. Those that will be agreed with the European Union will be incorporated in the European legislation, whatever you might think or say. Everything that will go through the sift and filter by the European legislation will be incorporated. Everything that shall not go through that filter shall not be incorporated. The Detector Media Public Organization. Welcome, dear colleagues. I will be brief. Firstly, let me echo the message of my colleagues to the effect that the current changes are beneficial and advantageous, especially as far as the regulation of online media. I also agree that there are some points to be regulated on the online. We see that in our practice. For example, the issue how the new legislation will treat a situation where you have an outlet that works at the crossroads of printed media and online media, but I think that we'll have a possibility to talk on that more specifically. Let me also draw your attention to a couple of points that seem to be very meaningful to me. One of those things is this. In this bill, you see the provisions on the martial law, and we've heard something which I don't believe in. I think this martial law is either going to last for some time and or such a situation may be replicated. So it's not only for today, the challenge is to balance the freedom of speech and censorship. We are likely to see the situation in the future. When other people come to power, the situation will be very relevant. I believe you are right. The Ukrainian state currently, very good, not badly, is regulating this issue. But it is very important for us to work in this sphere in the future. What is principal here is the implementation, the enforcement procedures. It's up to us how either to abuse the legislation or to test the will of the regulator to forgive breaches of law. Many people here have been working on the plan of Ukrainian recovery in the information area. And we say that if the half of the Ukrainian media survive after the war, it'll be a very welcome result, which tells us how deeply regulated the business is, including the information business in Ukraine. I support any changes, especially suggested by the people of the Institute of Information, targeting the liberalization. If you can decrease the fines, if you can decrease the punishment, I support that. And I'm looking at these in terms of the increasing of the independence of the regulator. Thank you. As for the martial law and law in general, we, unfortunately, are seeing a situation when since 24th of February, the regulator works on the basis of what I call peaceful legislation, because there are no specific powers, no specific regulations to act in accordance with the current situation. The law is very different from the media and the current processes that we are seeing. Unfortunately, the floor is given to the head of the National Association of Journalists of Ukraine. Thank you for giving this opportunity to share the journalists' view. We are appreciating the work that you have performed. Of course, you're stepping up to the enormous challenge to transform the Ukrainian legislation into the European one, and you're trying to find the answer to the questions that have been accumulated in our life. Our efforts are united. It's a good endeavor, I think. But we at the Association of Ukrainian Journalists, we've seen a number of thoughts on how to regulate the Ukrainian media legislation. What we hear is that media sphere, and it is objective, one, due to the Russian aggression, the industry is in terrible conditions, is in life support. The figures are saying that the real media problem for the Ukrainian media is this, that media are trying to get some payments from the public, and how to ensure that your staff are paid, which means that 75% of the Ukrainian media leaders are very much anxious about that issue. 25% of the media don't have any contacts with their boards, and 50% have cut down their staff. So what we are saying that the will to regulate all these spheres, to regulate them, will effectively be a negative factor that will squeeze out the journalists and the heads of the leaders of Ukrainian media, who are saying that they are calculating their way to leave the market. 10% of those have already shut their businesses down. Of course, for Ukraine, it's a high honor, the candidacy status. We support this idea of audiovisual services, and we offered to go step by step, phase by phase, to live up to those requirements, and then to work in different areas, to work with different colleagues. Let me remind you that in 1990s, we were proud of our freedom of speech, the lack of censorship, the lack of intervention from the state. But these laws, although they were passed in 1990s, they were supported by the editors, by the community. But today we don't see the point of view and don't hear the editors' boards of the real media. And of course, the Ukrainian Journalist Association is concerned about this, and we suggest that we should work on the political independence of the National Council to live up to the Constitution, where indeed we have this idea of media regulator in such a way to move forward and to muster the trust of the community to meet the challenges that we are facing. Now, of course, in these extraordinary times, the state must react to these campaigns, information campaigns, abetting and aiding the war rhetoric. But otherwise, what I'm saying is that we have a proposal to have the more broad involvement in these discussions. From my standpoint, let me share with you and your journalist association the law of media will simplify your access to all the resources in the European Union. Before the war programs, you know, these were programs that we didn't have access to. A lot of grants have been wasted, including the sector that you take so much interest in. So grants in 1990, 20, and 21 were wasted. They might have been utilized by the Ukrainian media sector. So I would like you to share this information amongst the well-respected members of the Ukrainian Association of Journalists, that you can participate in the European programs. Otherwise, if there is no wish to do so, then so be it. And again, you mentioned constitution. Constitution cannot be changed before the martial law is lifted, which means the victory. But let me ask you directly, do you support Ukraine in its negotiation for membership? Because if you don't support this idea, then it doesn't make sense. If you're against the membership negotiation and candidacy requirements, it doesn't. The deadline until the end of this year, my reply would be, and taking into consideration what the head of the parliamentary committee mentioned, there is some collision here that everyone is aware of. Let me remind you that I mentioned constitution from the point of view of the formation of the regulator. My personal standpoint is that, and the impression is that, the reforming of the regulation of media sphere are different things. Financial support and all the other things coming from the budget are conditioned on the availabilities of the budget, but there are some conditions that we must meet until the end of the year. I was asking, and I'm telling Oksana Romaniuk the following message. We are not closed in our ability to communicate with the members of the boards of published media. We are open, we will communicate. I personally am ready to share my thoughts with you. As for the communication, at our association, we have been analyzing whether the law will ensure that the financial pressure is increased. It would be very important for us to know from you practical things, how this particular bill will increase or decrease financial support. The free registration is provided for. Of course, there are other free services provided for. We would like to see specific article by article analysis where we might decrease the financial pressure on outlets. I am not blaming this bill in setting up a financial threat. What I'm saying is that for the printed media, it is very important to remember that they will not be able to live up to the demands of the local central regulator. There are other things that I didn't mention. The local broadcasting companies, for example, will see their liquidation because the regional, the oblast councils, where they have under their auspices these local broadcasters, they will have to cancel them to live up to the European legislation. There's a bad news for you here. This is what we've done in full conformity with the European legislation. Unfortunately, there is no way to go about it. We are aware of the complexity and comprehensive nature of this. And we are working with the local government authorities, and we will be taking on board other branches of authority to make sure that the threat that you are rightly mentioning would not appear even theoretically. When the bill, or no, the law is implemented, we should not see such pressures or dangers. If there is even a hint of such crisis situation, we will respond to this issue altogether. Thank you. I would like to give the floor to Tatiana Lebedeva, to be followed by Olga Kotyruba, the Opora Public Organization. Thank you. I would like to state from the beginning that what I am sharing with you is the point of view of the media expert, not authorized by the Commission of Ethics. People representing the Commission are here. As an expert, I consider myself to be dinosaurs, people who have worked for a couple of years within the National Council, in accordance with the older law. And when I read the new redaction, I was projecting all that has been suggested and proposed upon my expertise, and to be open with you, how easier it will be for the National Council to work. The criteria is more lucidly stated, the rules are clearly defined, restrictions are well defined. So I absolutely believe that the new option is much better. It has been improved very significantly as compared to the previous bill. In a nutshell, that was the first point, which is very pleasant. The Article 191, where self-regulation is quoted as an integral part of the information ecosystem. I understand that the law under discussion looks at the market from the economic point of view, but it responds to the spirit of the directive, challenging us to cooperate and to get self-organized. I think it's a very timely challenge that we must clearly delineate what is the sphere of responsibility of the government and what the media and are responsible for, what the media are responsible and journalists are responsible for. This community must be well aware of their responsibility, and it's good that it has been incorporated into Article 92. It's very good that you have provided for the changes into the law of support of the mass media. This law has been crying for the challenges, but there are duties and commitments by the journalists, where journalists are bound to supply only objective information, and journalists must live to the journalist ethics. I think this amounts to the revolution in our sphere. This is one of the mechanisms that remind the journalists of their commitments and responsibilities. I cannot help but say that the other reforms are also important. You mentioned the equality concept is very important, but deregulation has been performed in legal framework. How successful it has been maybe is a matter of controversy, but the communal electronic mass media, unfortunately, and they have not been reformed. I think it makes sense. I think that there are a lot of issues to be dealt with at the communal level. I cannot help mentioning 36 and 39 articles. You will remember that Article 9 in the Convention on Freedoms, I can't remember the full name of it, on fundamental freedoms, which says that the state is empowered to restrict some freedoms if this lives up to the legislation of a specific country. Ukraine has been under the criticism exactly because we did not have such criteria, rules, or provisions when we were banning some channels or media outlets. So I think Article 36 and 39 are currently very relevant. This is a hot button issue. There was a need for them for a long time. It's good that they're being implemented. Secondly, my friends, more often than not, we are afraid of changes. Sometimes the law has not been passed and it's been criticized. There aren't any perfect, ideal legislation that is liked by everybody. What is important here is that in practice, we are seeing the attempt to implement and realize the provisions of the new law. We are currently acquiring unprecedented expertise. Unfortunately, the price of this expertise is too high. But I think our commitment and duty to the next generations to live up to the legislation, to show the generations to come which laws are working, which laws fail to work. And I think that the time limit has expired already. This legislation must be passed. Thank you. Last remark. We have already overdrawn our timeline because the head of the National Council and the members of the task force will hold a press briefing. As you know, the NGO Opora is dealing with the oversight over the election process. We are all aware that the European Commission, on the one hand, has not voiced any specific demands to the voting code, but it should also be mentioned that this is a home assignment half-cooked, because all the provisions on promotion, agitation campaign, and how media work in time of votes, how it responds to the 2014 legislation, and they have copycatted into the voting code. What is important for us is that in this transitory norms should remain, because barring that, this regulation just will be lost. It would be safe to say that the current reduction that we see at the parliamentary side is a symbiosis of the work of the task force on the bill on media before the voting code was passed. Unfortunately, the voting code did not incorporate those provisions. And in the select committee at Parliament, we've got a task force working on the voting legislation, people that are working with the media also. They have been able to agree those points. I can only testify that the task force is transparent in its work, because we have been able to get the message across, messages that we think are important, and the task force at Parliament share their ideas with us, the experts in the voting rights. We understand that this is an area to find a compromise provision that will be lived up to by the media organization vis-a-vis a situation when you regulate the minutes, seconds, or hours when you're be on air, which is practically impossible to live up to. You have rectified everything that the mission of the OSCE has been pointing to in terms of the restriction of the role of journalists in participating in some voting process, for example, the right to response, the way it is stipulated now does not completely and utterly conform with the European practices. But you seem to have found a right compromise that is between the hard place and the rock of over-regulating the media, something that the businesses are emphasizing. On the other hand, it gives the candidate a right to respond. And the fact that you have regulated online media is very good. Online media and agitation, the promotion campaign, we are all aware as compared to the traditional media, the impact is unprecedented. So we give 2 thumbs up for this bill law to be voted into, this bill to be voted into law. Thank you. I suggest that 3 sentences to conclude from authors, Olga and then Stan, and we will draw the line. Colleagues, there is always room for perfection. We challenge you to come up with your proposals, that meaningful ones, constructive ones. There will be second reading, third reading. But again, we should not be better than the Europeans. We must not be more European than the Europeans. There are standards to live up to. I would also like to thank for participating and sharing your insights with you. As far as sectoral aspect is concerned, perhaps we will have some meetings online to shed light on these issues. We know the main thing. This process is irreversible. The law will be passed, and it is good. I also echo the latest point. Today, I have been convinced that all the participants of today's discussion are headed toward the point where the law is approved. We are excited about this idea, joining the EU, and we are supportive of our progress. So we are looking forward to the voting, and we will be banking on the members of the parliament who will realize how important this legislation is. Once again, thank you, the Council of Europe, and I would like to thank the Ukrinform for providing this platform to share our ideas with us in a completely volunteering way. Mr. Stan, the floor is yours.
Thank you for the participation. I think there will be found a solution. We are ready to come up with the advice on the regulation. Of course, the balance between self-regulation and, how should I say, law or rule-based regulation is always a difficult point, but I'm sure you will find the right balance there. We are ready to help you. I would also say thank you to Olya there for actually mentioning our colleagues in the OSCE, who unfortunately, due is also a victim of the conflict, if you like, and therefore is not here with us. But of course, we in the Council of Europe work very closely, with them on this issue. So thank you very much, and thank you very much for the opportunity today. I'm sure we'll reach the right result.
Дякую, Стен, Тарас і, можливо, Наталя, якщо є бажання, по два слова.
Дякую всім за обговорення. Процес
Thank
абсолютно
you, everybody, for your participation in the discussion. The process is open. Every stakeholder who wants to make proposals, you must take advantage of such a possibility. Now, of course, we must ensure that the powers of the National Council must grow. This is the requirement of the European Council, and this is the need. Alexander and I were working in the NGO sector, and we know that this is important. And irrespective of the fact that I am now working where I am, I believe in the empowerment of the national operator. We look forward to sending the translation of the bill to have it discussed, hopefully, at the European Council at the early September. Our task force, of course, continues to work, although we have grown tired a little bit, but we are open to different formats of communication, of meeting. Once there are people willing, wanting, and ready to talk to us, we will build up such communication. Thank you very much for your attention. We'll keep you posted.